Hear, all persons having business with the appellate are near, give your attendance, and you shall be heard. Be seated.
Good afternoon. Welcome to the Appellate Division First Department. As I call the calendar today, please ask for the time you actually need. And remember that if the panel has additional questions past the time you've been allotted, we'll ask them, and you'll have an opportunity to answer. About 5 hours of argument time has been requested, so we'll have to cut that down. We have read your papers, remember, and we are familiar with the issues that underlie your appeals. For those of you here for the first time, you should know that the white light on the lectern will go off when you have 2 minutes left, or if you've asked for less than 2 minutes, it will go on immediately. When I call your case, rise, let me know who you represent and how much time you're requesting. People versus Kevin Diaz. Submitted. Aosta v. Di Donato. Five and 2 and 5. I'm recused on that case, and so the clock will be handled by Justice Kennedy. MB Children is submitted. Mesa versus Old Republic. Five and 2 and 5. Give me a moment. No, here we go. Young Adult Institute versus the Corporate Source.
Appellant cross, respondent request 7 and 6.
Respondent, cross appellant request 6 minutes.
You also have time for rebuttal if you'd like.
2 minutes, Judge.
I'll do 7 and 2 and 7 and 2. People versus Guzman. Submitted. Vanguard Construction versus 400 Times Square.
Good afternoon. For petitioner, respondent, Vanguard Construction, 5 minutes.
5 and 2 and 5. Goldman versus Vanguard Construction.
Good afternoon, Your Honor. For the plaintiff appellant respondent, I'd be happy to address both the cross appeal and my appeal in one shot. 10 minutes for both.
I'd be inclined to give you some rebuttal, counsel, on both issues, but you want 10 minutes total, I take it.
Address both, and I'll just do 1 minute for rebuttal.
Okay.
4 and 2, Your Honor, please. 4 and 2, Your Honor, please.
Okay, I think we'll divide it 5 and 2 and 5 and 2. Thank you. Avamar, 57 fee versus Hunter Boot.
Your Honor, 4 appellant, 7 and 3.
I'll give you 5 and 2 and 4 and 4. People versus Alpha Wen. Submitted. Imperium Blue versus Marathon Asset.
Your Honor, 7 and 2 for appellant.
5 and 2 and 5. People versus J. McCrae.
Appellant request 6 and 2.
5 and 2 and 5. Rosenfeld versus Rosenfeld is submitted. Canal Rubber versus 6 Green Realty is submitted. The first case on from which I am recused is Aosta v. Di Donato.
Are we ready? Oh,
Ready?
know if there's a substitute judge. Good afternoon, Your Honors. My name's,
Speak up.
of course, my name is Mitchell Giddin, here for the appellant. There should be a reversal because in the first instance, the defendant did not show a prima facie case of the absence of material factual questions because Dr. Bianco, the defendant's expert obstetrician, was vague and non-specific in her claim that the delivery was accomplished.
Counsel, opposing counsel takes the position in their brief that you raised a new issue on reply. Could you address that?
I certainly will address that. The allegation that bill of particulars was failure to do a timely C-section. That's the material one, all right? What Dr. Lin, plaintiff's expert, did was elaborate and provide the reasons for that and the factual underpinning of that opinion. There was no question about the mechanism of injury or how fetal blood loss would cause the periventricular leukomalacia, that is the PVL, and everything that flowed by that, from that, the ultimate injury. If you look at the request for the bill of particulars, well, it's recited in the bill of particulars. There's no question about, what condition may have caused injury. The question was, what conduct is alleged, and the conduct is plainly alleged
They wanted a general statement.
in one of the broad statements.
Right.
Right. And there was obviously notice because the standard of care was to deliver in an emergency such as this within 30 minutes from decision to incision, okay? So Dr. Lin explains that in detail in his affidavit, whereas Dr. Bianco for the defendant made misstatements of the important facts by stating that the plaintiff was brought to the operating room at 12:45. Was brought there immediately when from.
Counsel, how do you counter the hospital's expert that, the hospital's expert's opinion that the injuries that was suffered by the infant was a result of being premature, not the cesarean section?
Prematurity was part of it, but what the defendant's experts neither dealt with was the blood loss that was shown, and I can be specific about that because there was the NICU discharge note and the neonatal attending admission note that is referring to the time of birth. That's record 3994 and 3998. That there was a peripheral IV was placed and 10 cc's per kilogram, 3 times normal saline bonuses were given for concern for hypovolemia and poor perfusion secondary to bleeding. That's got to mean fetal bleeding. Further, in addition to the normal saline bonuses, the admitting note says a 15 cc per kilogram. Now this baby is 1.17 kilograms. 15 cc's per kilogram of blood, O negative blood transfused, available from the labor room / OR, and epinephrine given for low blood pressure. So there's support for Dr. Lin's contention that there was, in addition to maternal blood loss from the placenta previa, there was also fetal blood loss. Dr. Koppel, the defendant's neonatologist, tries to dismiss the notion of fetal blood loss by saying that the blood indices were adequate, but they were taken many hours later after the transfusion. Similarly, the cord blood that he cites was non-acidotic, but that was well over, I think it was taken about 2 hours, was resulted in the lab 2 hours after the cord blood would have been, collected during the surgery. So again, we're left with the issue of fact on causation, but to return to the first principle is that there was a failure to even explain why it was alleged by the defendants or claimed by the defendant that there was no departure. There's no getting around the fact that there was a delay from when profuse bleeding from a placenta previa, which the defendant's doctors knew was in place. The intent was always to deliver before labor because of the high risk of bleeding. That at 11:45 p.m., speculum exam shows confirmed rapid bleeding. So the order is made to prepare the mother for C-section, and she's not brought to the operating room until 12:37. okay? Then from 12:37, they could do an emergency C-section with, and you can see with an incision at 1:04 and a delivery at 1:05, how quick the delivery was able to be performed. But there's an unexplained or unjustified hour delay, which is only characterized as being timely, no specifics given on, and no explanation of what the standard of care was. My red light's on.
Yes,
So I'm
and
going to
thank you.
address something.
You
in
will have
reply.
that on reply. Thank you so much, counsel. Give me a moment, please.
No problem. Good afternoon. May it please the court. Appellants
name?
of Jacob Bentley, my apologies, for respondent, York Presbyterian Hospital.
Thank you.
May it please the court. Appellant's new theory that the infant's injury stemmed from fetal blood loss along with maternal blood loss is a new theory and not
How so?
because, Your Honor, in the original bill of particulars, they discuss the timeliness of a C-section. And now appellant claims that the fetal blood loss was only a further explanation of why the C-section was untimely. However, that's not the case because the fetal blood loss claim goes to the underlying cause of the injury. Previously, appellant claimed it was the maternal blood loss, the maternal
Did your
bleeding.
expert, Dr. Bianco, fail to refute Dr. Lynn's statement that it's impossible to distinguish between maternal and fetal bleeding?
Dr. Bianco, Dr. Lynn's theory on fetal
Did
bleeding.
Dr. Bianco refute that?
Yes, Your Honor, because Dr.
How?
Lynn's.
Where? In what paragraph?
I don't have that in front of me, Your Honor, but Dr. Lynn's theory was based on the expected presence of vasa previa. That's what would have caused the fetal bleeding. Now, that later, and that was based on a March ultrasound that showed that vasa previa might be present. It was suspected but not confirmed. Later in that May, there was an ultrasound that showed that vasa previa was no longer a concern. And so,
Sorry, that doesn't, none of what you're saying goes to Dr. Lynn's statement that it's impossible to distinguish between maternal and fetal bleeding. When the bleeding occurs, Dr. Lynn said it's impossible to know where it comes from. How did Dr. Bianco address that?
Dr. Bianco addressed it by looking through the medical records and determining that this was maternal and not fetal bleeding. And back to the point regarding the new theory, the original theory that maternal bleeding is what caused the injury. That was the underlying cause.
The original theory was not that maternal bleeding caused it, but that a delay in the delivery is what caused it.
Yes, Your Honor. It's the timeliness of the C-section isn't what caused the injury, never.
But that was what plaintiff's allegation is.
Yes, Your Honor, but the reason why that C-section was necessary is because of the maternal bleeding, is the point I'm trying to make.
Well, but in the bill of particulars, the allegation was that the injuries were caused by the delay in conducting the cesarean, and there's no requirement that a bill of particulars be as detailed as you're suggesting it would have.
Oh, correct, Your Honor.
Particularly since it was just a general statement that was requested.
Yes, Your Honor. And the idea was that it was the bleeding, the general vaginal bleeding, the maternal bleeding is what made this C-section necessary. That's why it needed to happen when it needed to happen. By then adding on opposition to summary judgment that it was actually a combination of maternal and fetal bleeding was a new theory because it's getting to the underlying cause of why that C-section was necessary. What best illustrates this is a case appellant cites in DBV.
I'm sorry, I still don't see how you're distinguishing between the two, but I'll look further for that since you said you can't remember the paragraph that occurs in.
Yes, Your Honor. DBV Montefiore, which appellant cites in his brief, illustrates this dichotomy. In that case, there was the plaintiff in that the plaintiff in that case claimed hypoxia, a lack of oxygen to the fetus. And in opposition to summary judgment, that plaintiff's expert explained what caused that hypoxia. That wasn't a change in what was the underlying cause of injury. That was just an extrapolation of that cause. It's a further explanation. Here, plaintiff is changing is adding to a new cause of what caused the infant's injury. Originally maternal bleeding, but now it is a combination of maternal and fetal. So if it was a one-to-one analogy with DB, what would have occurred is appellant would have pled, as they did, that there wasn't a timely C-section, and the maternal bleeding is what caused, which would cause the C-section to be necessary, and then the expert would have explained, perhaps, why this maternal bleeding occurred. That's what happened in DB. That's not what happened here. What happened here is that that appellant added an additional underlying cause for these injuries and an underlying reason for why what occurred. And so it's not a one-to-one comparison with DB. And I see my red light's on. So
Thank you, counsel. Thank you.
A few things in rebuttal.
Just give me a moment. Thank you. Please.
I don't want to neglect to mention, as I wanted to get to before, that there was the service of the fetal heart monitoring strips after.
Can you speak in the mic?
The defendant served the rest of the hospital record, the fetal heart monitoring strips after the plaintiff's opposition papers were filed. That's why you have the rebuttal. But I think, it was fairly well dealt with by Dr. Lin to explain that he did not overlook what's essential. What I think my big disagreement with my colleague is that the plaintiff, and this should be clear, never claimed maternal blood loss as a cause of injury in a bill of particulars. Bill of particulars did not go into causation. The DB case really cannot, this court can't principally or reasonably be distinguished from this kind of a fact pattern or procedural pattern where, in that case, obviously from the reading from the decision, and I recollect it, was there were, the bill of particulars went into causation, et cetera. So there was, it was all foreshadowed. Really the analysis is much simpler, that there was no surprise, right? Because there was no, there was no alleging a particular mechanism of injury to the baby. And the standard of care for the emergency is a separate analytical issue. And once it's alleged that the surgery was needlessly delayed or with no good reason, the defendant was required to explain the timing, which was not done, and also the lack of surprise to the defense, because the facts of some fetal blood loss were plainly there in the record. As I mentioned before, I gave you those pages that there was a transfusion required, there was saline boluses required. Dr. Lin thoroughly explains why, as Your Honor points out, there was obviously some degree, a lot less, but there was fetal blood loss along with maternal blood loss as generally occurs.
Thank you both. Have a nice day. Thank you both.
Mesa versus Old Republic. Justice Gesmer is recused on this case. Please.
May it please the court, on behalf of appellants Old Republic and Chubb, I'm Ann Armstrong. This is a fairly straightforward appeal, Your Honors. Plaintiff respondent commenced this action seeking supplemental uninsured and underinsured motorist benefits. Benefits that were allegedly available in policies issued by appellants Old Republic and Chubb. Old Republic and Chubb's position, the motion below was granted in error because the court below improperly determined the contents of insurance contracts that were not at all before them. In addition, I should mention that respondent filed this, or not respondent, yes, respondent filed this motion almost immediately after the joinder of issue. There was no discovery conducted below
Who
whatsoever.
did
no
you,
PC
who did you, your client represent? Who was there insured?
Uber Technologies, Your Honor.
Was there a judgment against Uber Technology?
No, Your Honor.
When this matter, there was none?
No, Your Honor. There is a companion action in the Bronx that is sort of stayed but still active. There is no judgment currently pending anywhere against Uber Technologies for this accident. In addition to the issues with the policies themselves never having been put forth before the court, an issue that is apparent from the face of this record, the court also improperly determined several issues of fact with regard to the happening of the accident itself. Specifically, the trip receipt, because this was a ride that may have been procured.
Says, thank you for choosing Uber, Tiffany.
Tiffany, exactly. Roy Mesa,
Could that
as far
have
as we
been,
know on no discovery, is not Tiffany.
counsel, the driver was a female, right?
Yes, it was.
Could Tiffany have been one of her nicknames or something?
This is the receipt that's issued to the rider. This is not the receipt that's given to the driver.
Is it
We're
to
not
the
sure who
rider or
Tiffany
to the
is.
person that with the app calls for the ride?
It's given to the person who calls for the ride.
So maybe Tiffany called for the ride and someone else got in the car.
That's an excellent question. That's a great question that the court probably should not have determined without there being some discovery, which is sort of the point here. Roy Mesa is not Tiffany. Tiffany is not the person who drove this vehicle either. That is Ms. Zapinisiova, and I forget her first name, but I believe it begins with the letter D. It does not begin with the letter T. In addition, the accident itself is noted in the police accident report, again, which is in the record, is about 9 blocks or almost 1 mile.
Now that you mentioned the accident report, doesn't the accident report name the plaintiff here, Mr. Mesa, as one of the passengers in the vehicle?
Yes, he is an occupant. We are not saying Mr. Mesa is a jump-in. That's not what we're saying here. The issue is sort of combined. The policies not being before the court, the issue with the location of the accident versus the location of the drop-off versus whoever this person is that the receipt is issued to, all goes to whether or not Mr. Mesa could be eligible under these policies. This is impossible to determine on the very thin record that was before the court, which is only declarations pages for 2 Old Republic policies, 0 documentation whatsoever for any Chubb policies, and those declarations pages for the Old Republic policies create issues of fact. They direct people to forms that were not before the court. This record is very thin, and these issues are apparent on the face of this
How
record.
does Mesa get before the court to get what he's seeking in terms of the declaration?
I'm so sorry, can you ask that again?
How does Mesa get before the court? What does he have to do in order to get what he needs or what he wants, which is the declaration?
The declaration, well, first of all, he's got to get himself, set forth facts to show that he is eligible to recover under these alleged policy provisions. We do not concede that.
Does he need a judgment?
He needs a judgment to go against Chubb because Chubb does not have any kind of coverage whatsoever for SUM. If he wants SUM benefits, he may be eligible for those under one of the Old Republic policies, but definitely not both. Or he could simply continue with his bodily injury action in the Bronx, which is still active. He chose to change gears, commence an action in New York, trying to seek relief under these insurance policies, and then failed to put the full policies before the court or even get established that he's an eligible person to recover.
So as a passenger in the vehicle, is he, that action in the Bronx, is he also bringing an action against Uber and the driver of the Uber vehicle?
Correct. Those are the defendants in the Bronx. The other vehicle drivers, it was a multi-vehicle accident, but Uber Technologies and the driver are defendants in the Bronx.
Thank you, counsel. You have time in rebuttal.
Thank you.
Good afternoon, Your Honors. My name's Helene Blank. I represent the plaintiff and the respondent, Mr. Mesa here. I have to say this is the most difficult appeal I've ever had to prepare for, Your Honors. No, I'm not a regular appellate lawyer. I usually can zero in on the issues that will come before this court. For the first time in the respondent's brief, in the appellate's brief, did we hear the words coverage raised as an issue in this case?
Is a more fundamental question, though, Ms. Blank, whether under First Department precedent, your client had to obtain a judgment or have a stipulation allowing him to bring.
He doesn't need a judgment, Your Honor. This is a first-party benefit case. The citation to 3240 of the insurance law is completely and utterly misplaced. He is a covered person under this section of the insurance law, quoted in my brief. It's Rule 35D of the insurance law.
So what about Tower Insurance? This is our
Excuse
case
me?
from, Tower Insurance is a 2000 case from the first department. It
That's
sounds
not a
like it.
first-party case, Your Honor. This is a first-party case. This is a contract case. The 3420 actions absolutely require a judgment, because that would mean that my client was successful against the insured, and they didn't pay. So therefore, 3420 of the insurance law allows me, on behalf of that client, against the insured, to bring the action rather than directly against the insured, but to enforce the judgment against the insurance company. This is some coverage, Your Honor. It's first-party benefits. I pay, you pay, we can all pay for, other than standard $25,000 uninsured benefits, supplementary underinsured benefits, which means if you're in an accident, Your Honor, in my car, I have $millions of supplementary uninsured benefits. And if the car that hurt you, Your Honor, only had $25,000, you would have a direct claim
I take the
against my
point.
policy.
I think we take the point. Do you want to talk about some of the factual issues that the other side says require discovery? Like the
I'm very
receipt,
simple, Your Honor.
You know, Tiffany on the receipt,
Okay,
for example.
Very simple. 35D of the insurance law, the rule, under 11 New York CRR, subpart 60.2, it's at page 307 in the record, simply says you have to be a covered person. To be a covered person, you have to be a lawful occupant of the vehicle. Everybody calls of Uber for other people. Did it last night for somebody else. We all do it. Tiffany called this Uber for Mr. Mesa, who was his girlfriend at the time. He is a listed lawful occupant on the police report. The driver of the Uber says, this is the important things, the Uber app was on, she picked a male up at the time through the Uber app. That's important that the Uber app was engaged, which means Uber's insurance comes into play, and he was a lawful occupant of the vehicle. And this nonsense about the accident happened 8 blocks before the destination, well, of course, there was an accident. It was a serious accident. The car was rear-ended, then the driver of the Uber hit the front car. My client was removed to the hospital for 6 days from that accident. This was 09 a thing. And by the way, in the underlying case, which is part of this record, where they look to seal these insurance policies, they had their own experts talk about the fact that the Uber app was on, the timing, all of that. Nowhere, and these were the Uber's insurance people trying to convince the lower court, which they did in Manhattan, not in the Bronx, that they should have a confidentiality agreement, because these people know Uber's insurance, sir, and nowhere. So how it works is we notified them from the very beginning, as part of the record, that the underlying policy of the vehicle tendered the policy. That is a trigger under the insurance law. We then sent out not 1 letter, Your Honor, we sent out 4 letters to each policy, naming each policy, saying we are claiming uninsured benefit motorist coverage under each one of these policies for Mr. Mesa. And what did the insurance companies do here? Nothing. So 30 days went by. That triggers my client's right to start the very action he started. And in the complaint, which is part of the record, we list and name every single policy and its coverage as some coverage. In their answer, they denied knowledge and information about their own coverage. When we made the motion, Your Honor, after issue was joined, declaring that these policies were applicable, there's not one word that none of them have some coverage. Not one, until we got here. So now we're at the point in law in New York where a lower court makes a determination based on a record before it. And the loser says the lower court was wrong because I didn't tell the lower court what I should have told the lower court about mysterious documents that they don't even show to this court.
So I have a question. This is sort of like a no-fault application.
No, it's a contract action.
I understand, but here, you don't need to establish the fault of Uber.
No, because he's an innocent passenger.
Exactly. He's just claiming under the underinsured, supplemental insurance.
Supplementary uninsured motorist coverage, sir.
Yes.
That's all it is. And as long as there's a policy, and as long as my client triggers the applicability of those policies, which is one, he's a lawful occupant of the vehicle.
Thank you, counsel, if you can bring it to a close. That's all right. Thank you very much.
Just briefly, Your Honors, no matter how many times counsel keeps saying these policies, plural, were SUM policies, they are not. And that is
Isn't
the
it true, though, that
apparent
National
case of
Union
record.
did misrepresent its coverage?
I'm sorry?
Isn't it true that National misrepresented its coverage?
I don't know what National Union did. I don't represent National Union here, and they've withdrawn their appeal. I'm not quite sure. I don't know about their policies, but I do know that on the record here, if you look at it, which begins at page, I believe, 86, the declarations page is the only policy documents annexed. Again, only for Old Republic, not for Chubb. They do not show that these are SUM policies. Counsel was correct that the insured can elect to purchase it. That insured here is Uber Technologies. They did not elect to purchase it. It shows no such elections on the declaration pages that are present in the record, and there's zero information about that whatsoever with regard to Chubb's policies. I'll also point out that with regard to this contention that there were insurance experts below, there were not. There were some affidavits submitted by employees of Uber Technologies with regard to the functionality of the app, which again goes back into eligibility. It's not enough that the app is on or active. It has to be on trip. That is a question of fact. Had discovery been done, had this not been a motion made immediately following the joinder of issue, had there been a PC, had they responded to our discovery demands, had they made demands of our own, we may not be here today. Thank you so much. The decision below should be reversed.
Thank you, thank you very much. Thank you both. Young Adult Institute versus Corporate Source. Counsel, let me preface oral argument with the obvious fact that we won't be able to give you the time that Justice Schechter was able to give you below. So focus on what you really think is the most important issue. But in addition, if you would focus on whether punitive damages should have been dismissed.
Your Honor, we're happy to start with punitive damage. I would just note that
Yeah, thank you. I'll
my
take care of
clock.
it. Also give your appearance. Thank you, Mr. Scharf.
Y. David Scharf and Mark Jaroshow of Morrison Cone. We represent the corporate source and the individual defendants. Your Honor, there was no outrageous evil conduct or wanton disregard of anyone's rights that happened here. What I believe Justice Schechter fundamentally overlooked was the fact that there was a contractual obligation that YAI had to the corporate source, which obligated YAI and all of its employees.
Well, but that begs the question then, Mr. Scharf, why all the secrecy? Why all the secrecy by the employees?
Sure, because the history that anytime anybody tried to leave the YAI umbrella, whether it was New York League or Premier Health, or as is before this court, YAI's own board's recognition that if corporate source tried to leave, there was going to be no cooperation, there was going to be retribution, there was going to be takeover. And that's why the corporate source, in utilizing the employees that in essence were seconded to it, that had its own obligation to perform all of the obligations under the management agreement on behalf of the corporate source.
But it wasn't a complete stonewalling. I mean, Mr. Dutt, I think, did say to some of the employees, yes, share portions of the H drive with corporate source. That's not refuted, is it?
No, in fact, that establishes what Justice Kornreich said at the beginning of this case, which was all of the documentation that the corporate source got was its own documentation. The notion that there can be a breach of duty by employees and aiding and abetting when somebody is trying to get their own documentation, and some of that documentation is actually being directed by YAI. Your Honor, I think if we...
Some of it is, but nobody at YAI that I saw on the record said, oh, and take our vendors and send them over to corporate source too.
But the record does show, Your Honor, that those vendors were the exact vendors that the corporate source contracted with. But that was being facilitated by the employees of YAI who had been seconded to the corporate source. So it's not like they went and they took, relationships that belonged exclusively to YAI and then said, oh, help us get new relationships. We're talking about ADP, the payroll provider. It's exactly the same. Your Honors, if we personalize this for a second, I think we all know this was a very unhealthy relationship. Both parties knew the relationship was ending. It was month to month, and the corporate source had prepaid for it. This is analogous to, in some ways, to somebody wanting to leave a bad relationship. And when they try to leave that bad relationship, for instance, they go to the housekeeper and they say, can you do me a favor? Can you take out my personal checkbook? Can you get me my personal bank statements that I have that are in somebody else's study? And the housekeeper goes and gets that and gives it as somebody is trying to leave an unhealthy relationship.
But what if the housekeeper goes and gives something that belongs to the other party?
But that's not what happened here. What happened here, and as Justice...
So housekeepers work for both, parts of the couple.
Yes, and
that was not the case here. They were YAI employees, Quinn and Lapoff, until they were not anymore. They work for corporate source.
Your Honor, see, therein lie the fallacy and why I believe my analogy...
Is that not a fact? Is that not true, though? They now work for corporate source.
They were absolutely employees, and that goes to the heart...
And now they work for corporate source. Correct?
Yes.
At higher pay?
Sorry?
At higher pay?
They are now paid by the corporate source. The corporate source was paying YAI for them all along, and those employees and YAI owed an independent duty for the YAI employees while the corporate source was paying them to act lawfully, to act appropriately, and in the best interest of the corporate source. That's why I say this is no different than the housekeeper, because these employees, they had some...
Are you saying these employees, before they left YAI, had a congruent duty to both sides?
Yes, Your Honor. And
I find that very hard to swallow. I'm sorry.
It was born out of the contractual duty that YAI had that to perform all of the back service and back office duties. And once that contractual duty was there and exclusive, the YAI employees had a duty to exercise and do what they were doing in the best interests of performing those duties. And
so how do we, how should we, consider the fact that some of these, new vendor relationships, not only were they kept secret, but they were done through personal email accounts and not the corporate accounts. So how do we deal with that?
So first of all, they were not new vendor relationships, but the performance of the duties, all of the management duties, the financial duties, all of these things belong to the corporate source for its right to go forward. YIA was paid for those employees. They were prepaid during that period of time. You can't get hung up on the secrecy because the secrecy was born out...
He invites us not to.
Oh, yeah, that's it.
I respectfully suggest that not taking into account the way YAI acted towards other employees, to other not-for-profits for which it performed the duties, the fact that the YAI's own board of directors recognized that there was going to be retribution, there was going to be bad stuff, and the fact that since the termination occurred, YAI never gave to the corporate source anything that it asked for. The only reason the corporate source has been able to survive and continue to provide these adult disability employment services is because they were able to get everything out before the retribution campaign of giving them nothing and also suing them out of the retribution. I recognize my time has...
You have time in rebuttal, counsel.
May it please the court. Norm Srulo for Respondent and Cross Appellant Young Adult Institute. As your honors may see, not-for-profit does not mean not for revenue. And sometimes some of the factors that influence bad actors in the for-profit realm are ever present in the not-for-profit realm as well. Enter this case and this appeal. And that's why you have a situation where we have a 5,000-page record in this case. Judge Schechter was intimately familiar with the evidence and the facts here, and specifically found that all of the facts alleged in the amended complaint, which, by the way, was fairly detailed because YI, by that time, had had the ability to do some forensic work and see what these employees and TCS was up to, fairly detailed allegations. And as Judge Schechter said, the evidence really borne out everything that was in the amended complaint, including the secretive emails, the meeting and secret conference rooms, creating personal email addresses so that they could email data.
Counsel, would you concede that some parts of the H drive did belong to corporate source and that was fine to transfer that portion of the H drive to them, and there's an issue of fact about that?
Absolutely not, Judge. I think the evidence is clear below that the H drive was a large shared drive which could be downloaded, and evidence and information in that H drive belonged to YAI. It was associated.
Could it only be downloaded in toto?
I'm sorry, I didn't mean downloaded. I mean that there was information in that drive that belonged to, and that YAI was the custodian of, whether it was affiliated with TCS. There was other information.
Right, but some of that information on that drive originated from, and for lack of a better word, belonged to source. So if they got that back, there's nothing wrong with that, is there?
Well, Judge, that information that was associated with TCS, YAI was the custodian of that information. So, for example, if there was HIPAA-related information, YAI was the custodian for that and was responsible for it, even if it related to beneficiaries that TCS was servicing. So, and not only was it information related to TCS, there was information on that drive related to other network agents.
Wouldn't have TCS already have had that HIPAA information if there were patients? In other words, they'd have the HIPAA information and presumably consent to access it from the patients. So I don't really get that. In other words, why would that require you to withhold the H drive that pertained to the corporate source's business?
Well, I'm sorry, I might quibble with the fact, which isn't a fact, that why I withheld the H drive. They never had an opportunity to withhold the H drive because TCS just stole it. They used the YI disloyal employees, didn't put in a request for this information in the ordinary course. Of course, the TCS defendants are now raising all sorts of justifications for why they did what they did. Speculation as to how YI would have acted if they would have acted appropriately and made appropriate requests and didn't co-opt YI employees. But the fact of the matter is they did. And these excuses are just that. This isn't like a defense of duress where they have some bona fide reason for acting in the way that they did. It was completely unjustified.
There's definitely facts in the record showing an inference of breach of duty of loyalty. I grant you that. But let's talk about punitives for a minute. I just don't see it. Personally, I can't speak for the panel, but it's just not beyond the pale sufficiently to justify the continuation of the possibility of punitive damages in this case.
Sure. Look, I think punitive damages is a very fact-specific inquiry. Judge Schechter recognized the seriousness of the conduct at issue here. You're talking about defendants that completely wronged YI, impacted its ability to service the disabled community here in the tri-state area. And we believe a trier of fact would look at these facts here, including the deceptive nature of the conduct, and decide that this may be a case where punitive damages are appropriate. It's certainly, and respectfully, Judge, we don't think this is a case where punitive damages should be thrown out at the summary judgment stage where the trier of fact can't even consider it. So our argument in terms of the appeal is that Judge Schechter was correct in terms of reserving punitive damages for trial, and we believe the facts here, as Judge Schechter had recognized, will really bear out and already have, so that we will be able to establish that the egregiousness and wantonness and malice involved here for punitive damages.
So you're saying that the corporate source somehow aided and abetted these individuals in breaching their duty of loyalty to YAI?
That's exactly right.
And how did they do that? How did they go about doing that?
So TCS knew exactly, they used the YAI disloyal employees effectively as a Trojan horse to get the information that they wanted, to get the property that they wanted. So this was effectively, to use Mr. Scharf's example of the housekeeper, this was TCS finding a housekeeper to go into YAI's property, steal its property, and then induce it to do so, and then hire on that housekeeper at a much higher rate of pay. And that is typical. As the Judge Schechter below found, this is textbook, her words, not mine, aiding and abetting breach of fiduciary duty. A few other things that I wanted to touch on that Mr. Scharf had raised, which I think are important. And he said that these employees were seconded to TCS. That's not the case at all. Ms. Quinn was YAI's Director of Finance. YAI, she provided services to YAI, she provided services to TCS, she provided services to other entities within the YAI network. Mr. Sani was YAI's Chief Information Officer, the highest ranking information officer at the company. He provided IT services to YAI directly, he provided services to TCS, he provided services to other network agencies, as well as the two other individuals.
Okay, let's stop on Mr. Sawney for a minute, because all of these folks were at will, of course. You would concede that. And he just opened a consulting firm. He didn't go to work for Corporate Source. He has a consulting firm that provides services to Corporate Source. So is he a separate case?
He's not a separate case. He opened up a consulting firm, and the record reflects he has one and only one client. And conveniently enough, that client is TCS, in which he bills them and apparently takes in thousands of dollars a month. So he was induced, he acted, and now he was richly rewarded for his conduct. And by the way, I think this type of conduct is what a trier of fact might find that punitive damages are appropriate.
Thank you, counsel. You have time in rebuttal.
Thank you, Judge.
Your Honor, in order for the employees to have a breach of loyalty, there needs to be unfair competition with the employer, which doesn't exist here by the employees. There needs to be a diversion of business by the employees for themselves, which didn't happen, or improper kickbacks. So we start with the predicate that the conduct, secretive as it was, didn't amount to what would be, and for an at-will employee to be disloyal, to be liable for a breach of fiduciary duty to its employers. Now, let's remember, what were we talking about? We're talking about this notion of the Trojan horse, the housekeeper, and the record shows that it was entirely the property of the corporate source. The H-drive material was the corporate source. The vendors was the corporate source. And somebody who's planning to transition away business is allowed to make preliminary steps to discuss the potential of new employment with existing at-will employees. This is not the situation here where what the corporate source did was go and create its own competitive back office business and take away the YAI employees and set up its own business. It just needed to get out of the relationship, and the way to get out. So the
fact that it was in-house saves them from being aiding and abetting?
Well, it certainly should.
They didn't provide similar services to other organizations providing care for mentally disabled individuals.
That's correct, and that some of that goes to the heart of the economic justification defense here, where you have the corporate source just trying to do what is in its own best interest, which is separate and get the work done in a manner that it could be done on an ongoing basis. I recognize my clock is up.
Thank you very much.
Judges, I want to address a few things that Mr. Scharf had mentioned. One, again, with the H drive. I think the record is clear that the H drive contained a whole host of information, some associated with TCS, some not. I don't want to belabor that point, but in many respects, the H drive is a red herring because they took a lot of other information as well. The record is clear that these individual employees were emailing data and information to each other throughout the duration of this misconduct. So there was other data and information taken as well. With respect to the vendors, yes, Those vendors were, some of them were at least vendors that provided services to TCS during the period where the management agreement was enforced. However, let's back up and see what YAI does. One, it provides back office functions for the network agencies, including TCS. How does it do that? It curates and cultivates relationships with all of these vendors and creates economies of scale and is able to provide those services. They contract directly with ADP, with benefits providers, for them to provide services to TCS. So by TCS going out and ripping those vendor relationships away from YAI, using YAI employees on YAI to do that, damages YAI and the rest of the network agencies. And I also think it's important to note that YAI provides other services as well. It's not just a back office function. It provides direct services to individuals with disabilities as well. That is why TCS breaking away not only damages YI in terms of losing the back office functions, it competes and began competing with YI. For example, YI provides employment opportunities and services similar to what TCS does. During the period of the relationship, YI kept those services at bay so they would not compete and they would supplement, and TCS knew that. And some of that information with respect to YI's employment offerings were on the H drive that they stole. I think that's an important point to note.
Thank you much. Thank you both.
Thank you, Ron.
Vanguard Construction versus 400 Times Square.
Content could be found on the screen.
Sorry, Judge, that wasn't supposed to happen.
Talking to him.
Please.
Good afternoon, Your Honor. My name is Victor Worms. I'm here on behalf of the appellant, 400 Times Square. Judge, this is an appeal to reverse the lower court's decision, which granted Vanguard's order to show cause in a separately commenced special proceeding to amend non-pro-tunc a jurisdictionally defective notice of lien. Now, the jurisdictional defective lien can be seen in the record at 084 to 085. Now,
What document, what case law or statute provides that the lien, which describes the block and lot where the work was done, what case or statute establishes that the failure to name the unit in the condominium occupied by that block and lot is jurisdictionally defective?
Well, that's a very good question, Judge. Section of the lien law 9.7 says you have to look at the face of the lien to see whether or not it is sufficiently descriptive of the
Right, and why
property.
isn't a block and lot sufficiently descriptive? That's actually, in many ways, a more reliable description than the description used by a condominium, because unfortunately I've seen in our work many condominiums with contradictory descriptions of their units.
Well, Judge, in this particular instance, what made it defective was not the condominium description, it's the fact that it contained the superseding lot number 35, which was
Right, which they're now seeking to move to amend their lien to remove. So why doesn't that solve the problem?
It doesn't, Judge, because the notice of lien, the first notice of lien contained lot 1503.
But Mr. Worms, it contains so much more than that. It also describes the construction job. It describes there's a lot of information in here that gave, it seems to me, your client ample notice of what the lien was pertained to.
Well, that's not the issue, Judge. The issue is whether, under the statute, section lien law 9.7, it is on its face proper.
And do you have any cases that say that a lien that refers to a location where work was done by its block and lot number is jurisdictionally defective?
Judge, the block and lot number...
Counsel, could you answer my question?
Well, Judge, what I'm trying to explain that what makes the lien defective is not the fact that it refers to a block and lot number, it's that it includes information, specifically the superseding lot number, as well as lot 1503, which was not the lot that involved the work. 1501 and 1503.
But we're still waiting for chapter and verse on a case precedent. I think that was Justice Gesmer's question. What's your best case on that?
My best case, really, Judge, is the cases that shows And I'll give you a couple of cases, Judge. If you look at 343-349 East 56th Street LLC design, and that's at slip up 31955. It says very, very clearly that it is not a per se violation by merely having the superseding lot, but I'll read what it says. It says specifically, rather, the property description must be sufficient for the lien to be limited on its face to the property which the liener seeks to encumber. That means that if you have a pre-conversion lot number like 35, you have to have the specific lot number covered. You can't have additional lot. What made this specifically defective was the fact that it included lot 1503. 1503 was not where the work was
Your client
performed.
was the owner of lots 1501, 1502, and 1503, and it had authorized the work in units in lots 1501 and 1502. So it wouldn't have been misled in any way by the inclusion of 1503, correct?
Well, the issue is not one of...
Counsel, would it have been misled by the inclusion of lot 1503 in the lien notice?
Would it have been misled in the inclusion? It would have been misled because no work was done in 1503.
Right, so why would it have been misled? Since it owned 1503 and knew that the work it had authorized was only in 1501 and 1502. So it would not have been misled, correct?
But that's not the standard. That's not the test, Your Honor.
Counsel, could you answer my question?
We're talking about prejudice here, I think. That's what you're getting at.
That's what I want to know.
Yeah, so we don't see the prejudice.
How are you prejudiced?
There was only one immersive children's theater in this entire building. There may be only one immersive children's theater in all of Manhattan. So how were you not on notice? How is your client not on notice?
Notice is not the standard, Judge. The standard is whether on its face it properly describes the property. The law in New York is very clear. It's consistently clear. You have to identify the lot and block, and when you include a superseding number, you cannot have extraneous description that does not comply with
And
it.
what case holds that you may not have extraneous information? Is there any case that holds that extraneous information renders the lien jurisdictionally defective?
Well, when you combine the fact...
Counsel, is there any case that holds
The
that?
case law in New York is very clear. It doesn't say that...
Can you cite me a case that says that having extraneous information in the lien renders it jurisdictionally defective? I didn't see any such case in your brief. Did I miss anything?
Judge, you didn't miss anything. You just did. The law says that you have to have the lien satisfactory in its face. It's not a question of whether or not it applies to my client. The law very, very specifically says the lien must be proper in its description, and in this instance, it was not.
Thank you. You have time to rebuttal.
Good afternoon, Your Honors. John Simoni gets Fitzpatrick and now gets Platzer, counsel for petitioner respondent Vanguard Construction.
Counsel, before we begin, because we're talking about cases, and we all noticed that in your brief, you seem to allude to the fact that appellant's counsel perhaps use ChatGPT because some of the cases cited didn't really stand for the proposition stated. So I'd like to know, what cases do you claim were, generated by ChatGPT?
That we had a footnote specifically addressing that concern. And we said we didn't know whether or not that was the case.
Well, no, but I'm saying the way you said it, that's why I'm asking you, what do you believe, like particular cases that you believe that counsel used ChatGPT? Because to me, that's a serious, claim,
I believe the leading case was the ATA case, where it appears from the description given, which was fundamentally contrary to both the dicta and the rationale in that case. And I believe in the footnote where we made reference to it, that's the case we referred to as a most illustrative example of that.
So that's that one case.
I don't remember whether the footnote referred to others, but certainly was that one specifically.
All right, thank you.
Thank you, Your Honor. As the panel seems to recognized already, obviously, there's no need under the real property law or under the lien law or even specifically 9.7 to enumerate anything other than the block and lot.
But you can see that it is your burden to show that there has been no prejudice by the initial liens, incorrect information.
Right, and of course, we do demonstrate that in the record, firstly by establishing that there's no change in ownership. The sponsor for the development was 400 Times Square Associates LLC, and through the present, as I checked on Acris today, and as is shown in the record based on the pleadings, the answer and the complaint in terms of what was admitted, those three lots, 15101, 15102, 15103, are owned by the sponsor and continue to be. And as you'll see, we rely upon a number of lower court cases that have come out, Justice Tolub and many others, Justice Demarest, both in the first and second department. But you see the earlier cases in 96 and 97 in both the first and second department where the courts begin to recognize the need to look beyond, to look for whether there's prejudice, and to follow Section 23 of the lien law that provides for you don't want to do an injustice to the lienor. And so that's what we have here. As you can see from the record, there were two liens filed, one for one set of lots, one for another set of lots. And then the moment Bernard...
You're moving to amend the first lien.
Excuse me?
You're moving to amend the first lien, right?
That's what Justice Lattin ruled on. That's the one that we asked in the order to show cause. We relinquished and released the lien on the other two lots. We filed 3 notices of pendency because, again, we weren't sure we were dealing with. The 2 notices of pendency would let fall to the wayside. The notice of pendency on 1501 and 1502 is the only one we pursued to, not in this particular proceeding, but in another related proceeding. So, and again, no prejudice. It's Bernard Friedman and Robert Friedman, the same 2 gentlemen who have been involved from the beginning. And so the other point that was raised in the papers was the 12A proceeding. We, of course, said that it was properly presented as under CPLR 404.
You say it was very efficiently brought this way.
Right, very efficiently brought this way as a 12A proceeding. We had to bring in others that weren't party to the lien law foreclosure proceeding. And then there was an opportunity for my esteemed colleague's client to bring an motion to dismiss in that proceeding. So we thought it was properly concluded. And in the reply brief, of course, from 400 Times, there's no discussion on the 12A and method of proceeding. They simply abandoned those points after we...
Also, in the other case, you requested information from counsel numerous times about what is the correct designation of this immersive children's theater where my client didn't get paid by the...
$1.33 million, yes, Your Honor. And the response was, I believe my client owns lot 1502, which I'm sure he didn't do deliberately, but it just goes to show the problem in terms of trying to figure out which lots were applicable for this particular theater at this condominium location. I have nothing further to add. So.
Other questions? Thank you, counsel.
Just a few comments, Your Honor. First of all, I graduated from NYU in 1988. I've never, ever used ChatGPT. I don't even know how to use it. So I take umbrage to any suggestion that I acted improperly as an officer of the court and somehow conducted research by some artificial means.
But I think that the suggestion was twofold. One, that you might have done that, and maybe that was an over-the-top suggestion, but I think the bigger concern was that the counsel was suggesting that you were misstating the holdings of some cases.
I did not, and if you take a close look at it, what I did was I highlighted the law. So I take offense to any suggestion that I acted improperly. I've been a lawyer for over 30 years, and no one has ever suggested that I've acted improper in my research. One of the things I learned at NYU is how to do good research and good writing. So I take great offense to that. Let me get to the arguments that were raised with respect to the subordination agreement was never mentioned. That subordination agreement specifically identified the lot and block number of the immersive theater. He claims that he couldn't find it. It was a matter of public record. It was on Acris. So he could have gone there. He could have looked at it. What he did was he liened the entire building. The second lien and the first lien was against the entire building so that he could leverage my client into paying for work that was done by a tenant in the building.
But counsel, they did request that the information. They did.
It was provided to them.
But By then, they had already filed a lien.
But they filed the lien first. They could have looked at Acris, they could have gotten the information they needed. It was there almost 2 years before the lien was filed. So they didn't need any information from us in order to file a proper lien. Now, I understand that there has been some attempt to suggest that the law isn't the way I've stated it, but I've read Judge Stammer's case. By the way, I appeared before quite extensively before she retired. And what she said is that the face of the lien is what determines if it's valid. That's the point at which you look to see if it's valid, not at some later point. And when you look at the lien, you see that it doesn't comply both with the post-conversion and the pre-conversion analysis that the law applies here in New York.
Counsel, if I may, I asked the question because it wasn't a footnote. It was a small paragraph on the last page of the brief when counsel is making certain claims and allegations, and these are serious. So when you make those claims, you have to ask. And excuse me, I'm not done. So that's why I wanted to know what cases was he alluding to, and he listed one. So we'll go back and look.
Well, you know, Judge, to be quite candid with you, I'm used to these sort of attempts to suggest something about me improper, Judge. This is the way it's been for 30 years. I'm used to it. Thank you.
Thank you both. Avamer 57 Fee versus Hunter Boot.
You skipped.
Oh, I'm sorry. Yep.
The other
Gold.
Vanguard.
Yeah, the other one. Goldman versus Vanguard. Pardon me, counsel.
Confusing since we have two of them.
Good afternoon, Your Honors, and may it please the Court. My name is Kristen Gianaros for the Plaintiff Appellant Respondent, Ms. Valerie Goldman. First, with respect to the plaintiff's appeal, the motion court should have granted plaintiff's cross motion to amend the Bill of Particulars. The industrial code provisions alleged were squarely applicable to the facts of this accident and all related to the safety of pedestrians who pass by an active construction site. The amendment, therefore, was not impalpably improper or patently devoid of merit. I'd like to spend really the remainder of my
So they're
time.
not general provisions?
I disagree with the court's finding in that regard. And specifically, the case that the court relied on for that finding, McMahon versus Durst, only held that this labor law industrial code regulation is only too general to support a labor law 241-6 cause of action. Plaintiff isn't asserting any claims under that statute. Her claims are only for common law negligence, and she seeks to allege the violation of this regulation as merely some evidence of Vanguard's negligence. I'd like to spend the remainder of my time addressing the cross appeal. I think those issues are more substantive here. As to the defendant's cross appeal,
Speaking about, it's a negligence case, essentially. So the two employees that may have caused the fence to fall over, but in any event were eyewitnesses to the accident, were both not Vanguard employees. Does that end the case?
I think that's a wholly baseless contention raised by Vanguard. The only proof they point to for that contention are the accident reports filled out by these individuals at pages 516 to 519 of the record. And if you look at the reports, nowhere in the reports is this entity, Stephen Dubner Landscaping, identified as the employer of these individuals. And if you look at the section of the reports that actually request the subcontractor company name, phone, and address, all of those sections of the report are blank, and there's an NA notation not applicable. So we would argue that if anything, that notation gives rise to the reasonable inference that these employees were Vanguard employees and not the subcontractor's employees, hence the NA notation.
And the Vanguard employee who was deposed, Mr. Paulino, said the workers were probably not Vanguard employees. I would consider that not dispositive. How would you look at it?
I think that Mr. Paulino's testimony is critical here and raises the triable issues of fact that the motion court identified. All of his testimony here was entirely equivocal. As you mentioned, he testified that they probably were not the ones who moved the fencing, but maybe a subcontractor. He never conclusively testified or established that Vanguard's employees had nothing to do with this. He earlier acknowledged at page 472 of the record that Vanguard employees or a laborer was probably at the underpass project. And just on that point, contrary to my adversary's contention, they were discussing the underpass project at that line of testimony at page 472 of the record, not other sites at the Stony Brook Hospital site.
But Paulino also, I believe, answered yes at one point.
Yes.
When it was asked if he ever saw the Vanguard employees, and he said probably yes.
To be precise and to be fair to my adversary, he did testify. The question was, did you ever see a Vanguard employee or Vanguard contractor?
Okay.
And that was a compound question, but again, we're the summary judgment opponent. The facts and the testimony must be construed in the light most favorable to the plaintiff. And I think that line of testimony with his other earlier testimony all raises significant tribal issues of fact as to whether a Vanguard employee moved the fencing as opposed to some other subcontractor. So for those reasons, we respectfully request that the order denying the motion by Vanguard be affirmed and the order from which we appeal from be reversed. Thank you.
Any other questions? Thank you, counsel.
Good afternoon, Your Honors. I'm Judy Shamitzi from Wilson Elster for Vanguard. With respect to the cross appeal, the testimony was that he believes that only the subcontractor's employees would have moved the fence.
He also
does not.
said that the two individuals who were right there and probably were the ones who moved the fence were, quote, probably not Vanguard employees. That's not exactly, it seems to me his statement in itself creates a question of fact, doesn't it?
He at the deposition, he said probably not. He said, he was asked, would you remember them if they were your employees? He said, I would, and I don't remember them. And then in his affidavit, he clarified that they absolutely were not
Right, but if
Vanguard employees.
If he himself, puts in two contradictory affidavits, it seems to me that that's a question of fact.
Well, it seems.
Or let me ask it differently. Do you have any cases where an employee of the defendant puts in contradictory affidavits and the court says, okay, we'll grant summary judgment in their favor anyway?
Your Honor, all I can say is that as far as carrying the prima facie burden of whether these are Vanguard employees, and the burden is not to show that they're who else's employees, but not Vanguard's.
How do you establish that prima facie claim with an employee saying they're probably not Vanguard employees?
Because there is nothing in this record that would contradict that proposition. They probably were not. The fence would not have been moved by any of the Vanguard employees. That's his testimony.
But he
I
also
understand.
testified that he had seen Vanguard employees adjusting the temporary fencing.
He absolutely did not say that, Your Honor.
Didn't he say probably yes?
He said he saw either Vanguard or sub employees moving the fence. But that is really important here because he does not. The contract provides that the sub is going to manage the fence. The contract specifically, explicitly states that. That's in the contract. On top of that contract, and I do beg of this court to consider the summary judgment showing in its whole. Part of it is the contract which says the sub is going to manage the fence. Part of it is the GC's testimony that says either a sub's employee or one of mine, yes, I would have seen them move the fence. Part of it is saying, I would remember these people if they were my employees. I don't remember them, and they were probably not my employees, followed by an affidavit that says they in fact were not. And then you have a form that is not a Vanguard form. It is a form specifically for subs to fill out when they're reporting up to Vanguard that there was an accident. That is the form that is filled out, and on that form, by the way, it says, and I don't want to lean into this too heavily, but just to respond to the point that nowhere does it say who these people were. It actually does say on the accident form that they were the sub employees. So it does identify SDL on the accident form, but that.
But aren't you ignoring the fact that we have to, have to consider the facts in the light most favorable to plaintiff, who's the non-moving party?
There are no facts that connect these employees to Vanguard. There are none. There are only facts that, with varying degrees of certainty, establish that they were not Vanguard employees. Those are the only facts. And in response to that, their identities, aside from the fact that their phone number was on the accident sheet, their identities were disclosed as witnesses in the discovery exchanges. They could have called them, they could have deposed them if they wanted to ask them, who were you employed by? They probably wouldn't have liked the answer, but regardless, the prima facie showing as a whole establishes that Vanguard does not move the fence. It specifically contracted to its sub the obligation to move the fence, and all of the testimony is fully in accord with that. And that is enough. The prima facie showing doesn't have to be entirely airtight. It is enough to tip the scales that it is probably more likely than not, this being a civil case, although I do think that this kind of showing may qualify us for a criminal burden, but certainly more likely than not, these were not Vanguard employees, and there is nothing on this record that says that they were. So that, Your Honor, is...
Counsel, that is the main event. I agree with you. But say we allow this complaint or this case to go forward, why not amend the BP, at least with the apropos sections of the Industrial Code?
Their original BP disclosure says that they were going to ask for jury charges that identify the various code violations that may be at issue. I think that it is up to the trial court and the trial court's discretion whether they allow it in the BPs or whether they're going to take that up at the charge conference. Frankly, I do think it is more appropriate for the charge conference. I understand the point that if there is a regulatory violation, that may be some evidence of negligence. I think the trial court, in its discretion, can hold. It's not going to entertain that in the BPs.
All right, thank you, Counsel.
Thank you, Your Honors.
Just briefly on the main appeal, allowing a plaintiff to amend a bill of particulars during the course of the litigation is very common issue that happens here.
No, and as a counsel, as trial counsel, you wouldn't want to go into the charging conference having had your amendment to the BP denied, right?
And I
you can
think,
say, hey, Judge, you know, now we have the trial evidence, let's put these industrial code sections in as evidence of negligence. But still, you might be having a little uphill battle in that if you already had your motion denied to amend your BP. Would you agree with that? I think you would.
I think I would, but I think it's entirely appropriate to amend the bill of particulars in the way that plaintiff did here. It wasn't done on the eve of trial. There was no prejudice even alleged by the defendant if this amendment were to be granted, and there are no new legal facts or theories being alleged. This has always been the same fact at issue, a fence that fell on plaintiff as she was passing by a construction site.
Would you concede that this section is very long, 23-1.33D, which is about maintenance, is simply about and sub 1, is simply about the ground that you're walking on not being proximate to a construction site. And it wasn't that she said she tripped on the fencing that fell over, it rather fell on top of her. So you'd concede that that one's maybe not applicable?
I think it's applicable because the fence was clearly an obstruction. She was walking and this fence obstructed her path in that it fell on her.
She didn't trip over the fence.
She didn't trip, it struck her, but I do think that in a sense this qualifies as an obstruction because it fell on her. It obstructed her path as she was proceeding forward. But surely, Your Honors, the 23-1.33A, 1, 2, and 3, and B, 1I, I think are indisputably relevant to the facts of this case. They squarely apply to a situation where a fencing is not so properly shored, constructed, guarded, arranged, so as not to endanger any person passing by. And that's precisely the facts of what happened here.
Thank you, counsel. Thank you both. Avamer 57 Fee v. Hunter Boot. Please.
Good afternoon, Your Honors. May it please the Court. Kara Garicki here on behalf of Avamer 57 Fee LLC, plaintiff appellant in this action. Seeking reversal of the court below's decision dismissing Avamer's claims for breach of contract against defendants' respondents on a successor liability theory.
Counsel, it seems to me that your argument about continuation depends on our holding that the continuation can be done by two corporations instead of just one, if there are two corporations acting in concert in some way. Is there any, what is your best case to support that theory?
Yes, Your Honor. My best case on that point, there are actually two of them. One is TAP Holdings versus Oryx Financial, this court's decision 109 AD 3D 167. It's a 2013 case in which senior lenders created a new company in order to shear the predecessor company of its assets so that the unsecured creditors could not get what they were owed, and then continued the company TAP's business once the successor company was formed. The second case is a Fourth Department case, Lippens, 138 AD 3D 1507. In that case, two companies, there were actually three asset purchases, two of which were at issue in that case, where companies purchased assets out of bankruptcy in Germany, including trade names, logos, as well as equipment and other things. And the Fourth Department held that they could be found liable for successor
Okay, counsel, so
liability.
say, even if we agree with you there, for the mere continuation exception to the general rule, don't you also have to show that all the assets were stripped by the colluding corporations? And here, in the bankruptcy proceeding, or whatever its equivalent was in England, other creditors were paid. You know, some money was taken from Hunter Boot and given to non-parties. So doesn't that defeat the mere continuation doctrine argument in this case?
I do not believe so, Your Honor. The interesting fact in this case is that Authentic was on both sides of the transaction. Authentic acquired Hunter Boot Limited and Hunter Boot U.S. assets. Hunter Boot U.S. was in fact stripped of all of its assets as far as we can tell from the record, and had to...
So you need to isolate Hunter Boot U.S. in that case for your argument to hold up?
Yes, the case is about Hunter Boot U.S. We don't know the full details of the overall transaction. Here we only have the two asset purchase agreements that were submitted by Authentic, but Authentic is actually part of the overall transaction, including in the UK, based on the public reporting that we appended to the complaint when we filed the action.
Did Hunter Boot pay you rent after the asset purchase agreement?
Yes, Your Honor, but the interesting part about that is the documentary evidence that was submitted by Authentic, the two asset purchase agreements, had a 60-day period in which Hunter U.S. was to continue selling inventory on its own behalf, and there would be negotiations as to price. As soon as that 60-day period ended is when, it's in Record 71, a letter was sent to Avamer by Hunter U.S.'s parent company saying it had run out of money, it had gotten rid of all of its assets, all or substantially all of its assets, and could no longer pay rent.
You concede under both asset purchase agreements that neither purchaser assigned or assumed contracts of Hunter Boot, right, USA? I mean, they say that. That doesn't mean that you're done, but that the relevant contracts do say that.
Yes, Your Honor, but under this court's decision in Burgos versus Pulse Combustion, that's not dispositive. Another thing of note is that in the Fisher Asset Purchase Agreement, there's express reference to the lease that's at issue in this case, and that provision states that Fisher was going to try and work something out. I'm using that term colloquially, of course, it's a more proper provision, was going to try and work something out with the landlord. On that basis, a reasonable inference could be drawn at the pleading stage that there were discussions about the lease, that Hunter U.S. believed something could have been worked out, and did not notify Avamer or attempt to make an assignment under the bona fide sale provision of the lease due to that representation that's expressly in the contract.
Thank you, counsel. You have time in rebuttal.
Thank you, Your Honors.
May it please the court, Anthony Passioni on behalf of Authentic Brands. I'm from Cat Mutual. Your Honors, I'm going to address the mere continuation point. Counsel for Fisher will address the fraud and tortious interference cases. And I think it's the most efficient use of time. I want to start with two basic principles in case law that the appellant completely ignored in their appellate briefs. The first, which comes out of the cases Wasvie County of Nassau and Cargo Partners, is the fact that the mere continuation exception applies where the original corporate entity itself continues and not just the business. It has to be more like as if the successor company is just flipping hats with the other company. The continuation of the business.
There's no case law that absolutely says it can't be two corporations that take on the identity of the first one, right? And in fact, the Fourth Department case that counsel cited very much suggests that it can be two corporations who take on
Your Honor,
the identity of the company that's at issue.
And I'm glad you raised the point, Your Honor. It's extremely important. The case that they rely on mostly for this point is the Lippens case, which they raised for the first time in their reply. Right, we've had 4 sets of briefs. First time we see Lippens to stand for the proposition that you can have multiple purchases of assets and still satisfy the mere continuity exception. However, that is an entire misreading of that case. In that case, the issue was whether or not the entity called Bakery in the decision was a mere continuation of Winkler USA. And when you look at Bakery and Winkler USA, what you will find is the court finding that there was an asset sale agreement specifically identified Winkler USA as the seller. The agreement conveyed all of Winkler's USA's inventory, contracts, commitments, customer agreements, blah, blah, blah. It also obligated Baker to assume all employees of Winkler USA and obligated Winkler USA to assign the bakery the lease from Winkler USA. There is only one entity, Bakery, that purchased Winkler, the USA assets. The other entities at issue in that case purchased some stuff in Europe that has nothing to do with mere continuation. In fact, mere continuation wasn't even alleged against those other entities. And so I had to read this carefully because I saw that case for the first time thinking, oh my gosh. But it's a complete misreading of the case.
I'll read it again. I didn't read it the way you read it, but now I'm curious to reread it.
You should, Your
I didn't
Honor.
read it that way, I have to say.
And the other thing is, Your Honor, just to gild the lily, that case is a personal injury case. And in Lippens, the court specifically says that in personal injury cases, we're going to be more flexible with regard to these standards. It also says that the issue of mere continuation is basically raised in one sentence. Finally, Your Honor, nobody raised this. It's not an issue that was squarely presented to that court. Nobody raised the argument you can't have mere continuation. And that's probably because only one entity was accused of merely continuing, and that entity was Bakery. So I think that's an extremely important point, Your Honor. Back to the first point I started, which is it's got to be a business reorganization as opposed to a sale of assets to continue a business.
I have a question about the two asset purchase agreements. The asset purchase agreement between Fisher and Hunter designated Authentic as the principal obligor with respect to Fisher's obligations. And Fisher's agreement with Hunter US was stated to be made for the direct benefit of Authentic. What relationship do those two assertions in the respective asset agreements lead to with regard to the relationship between Fisher and Authentic?
Your Honor, the obligation of Authentic under the Fisher agreement is as guarantor. It was apparent that for whatever business negotiation reason, somebody wanted Authentic's imprimatur and financial backing to satisfy the Fisher transaction, and that's what occurred. There's also provisions in those agreements.
And what about Fisher's agreement describing that it was being made for the direct benefit of Authentic?
I believe, Your Honor, there's a provision in the Fisher agreement which says that it is there are no third-party beneficiaries to either of these contracts. And so, Your Honor, so I realize my time
30
is up.
seconds.
Thank you.
No, I mean, you have 30 seconds more if you want to add anything. If you want to.
Well, thank you, Your Honor.
Okay, I'm not asking for anything. I just wanted to give you a shot.
I'll rest for now, thank you.
Okay, thank you.
Doesn't get it for now, that was it.
May it please the court, Richard Shore from Nixon Peabody, representing respondents Mark Fisher. So on the Lippens case that was just addressed, there's a couple other really relevant points here. It is a one-for-one asset purchase, as esteemed counsel described, but also it's an instance of shared management and shared ownership, right? In Lippens, these are related entities. They're all related entities. The seller, the buyer, the other entities, they're all related, right?
The other buyer.
Shared management and shared ownership.
Do you agree there was a second buyer?
No, the other entities there is no second buyer under the one asset purchase agreement. There were other asset purchase agreements related to other assets from the German entity. But the USA entity, Winkler USA, there was a single asset purchase that was purchased by a single entity bakery. The point that I was making about continuation of ownership and management is an essential element here of mere continuation. And
Do we shift to fraud, though? Because I'm going to ask the other side about fraud. Is it a pleading matter, just the complaint? I mean, obviously, there's a motion to dismiss.
Pleading matters is, frankly, it's not even close. And they acknowledge in their reply brief that they have no knowledge of the fraud. They were unaware of the transaction. They relied on Google for their allegations. And, quote, there are very few details. They know, quote, very few details about the transaction. They also completely ignore the six factors.
Not surprising at this stage? I mean, there hasn't been any discovery.
You have to plead fraud with some specificity. That's the standard, and there's no specificity whatsoever. They don't allege a single fraudulent act. There's 6 factors of the fraud exemption that are necessary to impose successor liability, and we go through them in our papers on page 30 to 31. They literally don't address them whatsoever because none are present here. And a few of them: close relationship among the parties in the transaction, not alleged; inadequacy of consideration.
They do allege a close relationship between Hunter and Fisher. I'm sorry, between Fisher and Authentic.
It's between the seller and buyer.
Between Fisher and Authentic, correct? They do allege a close relationship between Fisher and Authentic in their complaint, correct?
They allege that they are vaguely partners and that it's an agent, and that
The vague was missing from my copy, but okay.
they allege that they are partners and that Authentic is an agent. That's what they allege.
Okay.
With nothing more. But the close relationship requirement in fraud is actually between the seller and the buyer, right? And so there's no allegation of the complaint that that Hunter and Authentic, or that Hunter and Mark Fisher had a close relationship. These are arm's length transactions. They don't allege inadequacy of consideration. They don't allege use of fictitious parties. They don't allege retention of control of the assets after the conveyance. So what appellant does allege is merely that respondents knew about the lease, didn't acquire it, and then knew that Hunter breached. That is not fraud. That is not an allegation of fraud. That respondent deliberately structured an asset purchase agreement to avoid lease obligations is not fraud. There's nothing fraudulent about a buyer choosing specific assets in an asset purchase to purchase, but not purchasing others. If so, it would render all asset purchase agreements of less than all of the assets fraudulent. And with respect to tortious interference, it's a similar analysis, right? If the respondents deliberately structured the asset purchase agreement to avoid lease obligations, that does not amount to tortious interference. So they don't cite a single case where a court found tortious interference for simply entering into an asset purchase agreement and excluding the purchase of other liabilities. I see I'm out of time. I'm going to refer the court to 2 cases in particular, which are directly on point: motions to dismiss tortious interference claims in the asset purchase context. It's Kine Operations. That's a First Department 2021 case. And Beecher versus Feldstein, which is a Second Department 2004 case. And that's a case where there was, just like here, it was a lease. There was an asset purchase. The successor entity allegedly purchased the business, but excluded the lease. The landlord brought a claim, and the court dismissed it on a motion to dismiss.
Thank you. One more question, counsel.
One more question. Could you explain? It seems to me that in your brief, you refer to various matters relating to Hunter's status with the Delaware Secretary of State, none of which are in the record before us. Can you explain to me why you would include matters in your brief which are not in the record?
I mean, they're public record, but otherwise,
Sorry, that's not an exception we recognize.
we'll rely on the allegations in the complaint. They do not allege that Hunter does not exist. So if we just look at the complaint, the allegation in the complaint was that Hunter still existed.
It's better practice not to mention things not in the record, counsel.
Noted, Your Honor.
Thank you.
First, I'd like to note that our understanding of the case law is that we did not need to allege that Hunter US no longer exists. Under TAP Holdings and Burgos versus Pulse Limited, it's the company effectively ceased to exist. And here we have a company that clearly, based on what was appended to the complaint, was going into dissolution, had no assets, and no money. So we believe that that satisfies that standard. In terms of our fraud allegations, the standard is under TAP once again, where a complaint asserts that the predecessor corporation was rendered insolvent by the defendant's actions, that can support a fraud claim under successor liability. And I do not disagree that there are factors that are considered. But with respect to those factors, Hunter was not insolvent prior to the asset purchase and had not declared bankruptcy. That's alleged in the complaint at paragraph 44, record 23. After the asset purchase and that 60-day holding period I had referenced, it no longer had assets or monies to pay the rent. It was rendered insolvent by that transaction.
I didn't see any evidence in the record that actual cash was paid to Hunter as part of the asset purchase agreement. Was there any such evidence in the record?
Your Honor, that's another point that I was going to actually mention, is that we don't know what the consideration was such that we could challenge whether or not it was fair. We were at the pleading stage, and you are correct. The asset purchase agreements do not state what consideration was paid for the assets.
Thank you.
I'm out of.
Please continue, counsel. You can, 30 minutes, 30 seconds, pardon me. 30 minutes. We'll be here very long.
Thank you. Also, on the agency point, I just wanted to state that the asset purchase agreement clearly supports the agency theory, and Avamer alleged that Fisher was Authentic's agent in the complaint. Authentic had obligations of collection and payment in the Fisher agreement. Authentic, not Fisher, provided a limited license for Hunter US to continue selling goods and use the Hunter logo as part of the Fisher agreement. And Authentic had to be consulted on issues concerning the sale price of
Thank you, counsel. We have your briefs.
you, Your Honor.
Thank you both. Thank you all. Imperium Blue versus Marathon Asset. Please.
May it please the court, Robert Smith for Marathon Asset Management and Marathon Real Estate Acquisitions. This case is governed by a term sheet between Imperium and Marathon. Dissatisfied with the deal it struck, Imperium alleges that someone at Marathon, it doesn't say who, made vague oral promises collateral to the term sheet that Marathon ultimately failed to honor. Imperium's claims for fraud and promissory estoppel fail for two reasons. First,
I mean, you lead with the point that the term sheet does not obligate either party to complete the financing.
that's correct, Your Honor.
That's a pretty strong point.
I think that is a strong point. I break down there, so the 2 points are lack of reasonable reliance in this case and failure to comply with CPLR 3016. On reasonable reliance, their theories have shifted somewhat throughout these proceedings, but I put the alleged promises into 3 buckets. One was a commitment to close by a date certain. They allege that repeatedly in their complaint, and we cite the paragraphs in our reply at 6 and 7. That is flatly contradicted by the term sheet. Under
Term
no
sheet it provided that at the earliest you were going to close on December 17th, is that correct?
That's correct, and that was an anticipated closing. That's what the term sheet says. It didn't say that anybody was bound to close. It was entirely dependent on my client's sole discretion as to whether or not they were going to close. So I can't see any daylight between an allegation of an oral promise to close by December 6th and the term sheet. It's just flatly contradictory.
Now, there's no merger clause here, right?
There is no merger clause, but we don't need a merger clause under this court's precedents establishing that when you have an oral promise and you're presented with a term sheet that contradicts the oral promise, reliance is unreasonable as a matter of law. And so their second bucket of argument is essentially that my client promised to use good faith and to, I guess, to use best efforts. That too is contradicted by the term sheet in this case. This is in the record at page 83. It says that my client wasn't obligated to negotiate a commitment for the proposed financing. And it also says that my client wasn't making any commitment, offer, undertaking, or agreement of any kind. So
the term good faith, they argue that we should pour into that term your prior relationships, the prior deals that you all have done together, and that they thought if they gave you this job that you would get it done on time because you had in the past.
Yeah.
In time is defined by them.
The problem with that allegation, Your Honor, is again, it is contradicted by the term sheet. As a sophisticated borrower in this case, as alleged, presented with a term sheet that flatly contradicts every promise, they could do two things. They could negotiate a new agreement, or they could walk away to another lender. They did neither of those things here.
Well, they said they were dissuaded from walking away by your client.
Well, if that was the case, then none of this court's precedents on reasonable reliance would hold any water. You could contradict any written agreement with some kind of promise, which gets to the second problem at issue in this case, which is that they haven't detailed the allegations of alleged misstatements in this case. This is not a case where someone is alleging that it's impossible to know these details of the fraud or misrepresentation. They allege that they were the recipients of this, but they won't say who at Marathon said these things, when they were said, in what context, and what precisely was said. And those details matter under the CPLR. Their only argument is essentially that this court should not extend that to their allegations of misrepresentation as it applies to their claim for promissory estoppel. That is contradicted by the CPLR. The CPLR says when there are allegations based upon misrepresentation, that's enough for the CPLR to apply. And I'll give you two cases that illustrate this point. Neiman versus Felici, that's at 55 AD 2nd, 521. In that case, even though fraud was not at issue, it was an unfair competition claim, this court said that the claim sounded in fraud, so CPLR 3016B applied. The third department did a similar thing in Rotterdam Ventures versus Ernst & Young. That's a 300 AD 2nd, 963. And the Second Circuit has done the same thing in its equivalent of 3016B. And that's in the Rombach versus Chang case, 355 F3rd 164. And for that reason, courts have repeatedly applied heightened pleading standards to claims of promissory estoppel premised on misrepresentations. The Eastern District of New York has done so. We cite that in our reply brief. The Ninth Circuit has done that as well. And so for both the reasons, we would ask that this court reverse and that it would instruct that the Supreme Court dismiss these claims with prejudice. And the reason why we're asking for a prejudicial dismissal here is there is no allegation that they can bring to contradict the nature of this term sheet. Thank you.
Thank you, counsel.
Good afternoon, Your Honors. If it may please the Court, Caroline Walters on behalf of respondents, the Imperium Blue Companies. So, Marathon is essentially taking a radical position that if there is a non-binding term sheet, where the ultimate commitment isn't binding.
Right. Well, it seems to, I can understand why they're taking that position, because on the record on page 83, it says, under no circumstances should the terms and conditions contained herein constitute or be deemed to constitute a legally binding commitment on the part of lender or any of its affiliates nor shall they be construed as an offer or undertaking by lender to issue, arrange, or negotiate a commitment. And that's about the 5th time in the term sheet that it says something like that, basically that this is just an agreement to start work, not to make you a loan. So I don't understand what your basis is for claiming that they had any obligation.
So, again,
in the term sheet.
We aren't alleging breach of the term sheet. That's not the claim we brought.
But why doesn't the term sheet supersede any oral statements made to you? You had conversations with them and then you signed a term sheet.
Well,
how would that, under what theory do those original promises, if they existed, continue to hold any water once you signed a written term sheet?
So the radical position I see is that it can't be that the case that there's a non-binding commitment in a term sheet allows them to defraud my client. And
Where's the fraud? I don't see
oral
any.
assurances, sorry, go ahead.
Where's the fraud?
Well, they misrepresented that what documentation they were going to require. They misrepresented their ability to
They said that
complete
perfectly
this.
clearly in the term sheet. They said what they wanted. You're claiming that they were entitled to less because of things they'd said before, but in the term sheet, they were pretty clear about what they wanted, weren't they?
Well, there are two things here. There's sort of 3 buckets of allegations. There would be the oral assurances before inducing us to enter into the term sheet, which are collateral to the term sheet. They aren't directly covered by the term sheet. 2, there is the omission that our allegation is that they omitted to tell Imperium that they didn't actually have the ability or desire to close in 2021. That has not ever been addressed in the pleadings, in the briefing. Marathon has
How
stayed
does that
silent on
contradict anything in the term sheet?
I'm sorry, I haven't said.
How does that contradict anything in the term sheet?
Well, the term sheet, well, that's the point. This isn't about the term sheet. This is about the oral assurances. And the oral assurances continued after the parties executed the term sheet. After executing the term sheet, when it became clear to Imperium, they didn't think that Marathon was moving forward in the manner it had represented it would. Imperium then tries to terminate the contract, and Marathon says, no, we'll get it done, don't worry. And we do.
Is that when you allegedly we'll get it done by December 13th, something like that?
Yeah, so December 6th originally.
So my question is, how is that fraud? Because how could your client walk away? I mean, this was during the exclusivity period, so please explain that.
Well, I think there are several reasons the client could have walked away, and one of which is, I mean, it could always terminate a contract, and if some fallout for that happened, that would have been, we would have been able to figure that out, but they needed to be told the truth. The fact that there's a non-binding provision in a term sheet doesn't give right to Marathon to not tell them the truth and induce them to continue working with them in an exclusive relationship without, the benefit of the facts. And it's not that the trial court didn't consider the term sheet. What she said is the term sheet, based on Marathon's own position, the term sheet doesn't create a contractual commitment, so how could any fraud arise out of the term sheet in the first place?
Can we go back to counsel's other argument that, the complaint doesn't allege when the promise was made, to who it was made, who made it, and, what was the alleged promise? Can we talk about that?
Yeah, absolutely. And I think that that's not consistent with the complaint. The complaint alleges specific dates. It alleges, it quotes emails. To the extent that there is, I just don't even know what would be really missing here. I mean, it does include the dates. It does include quoted language. And I think the real question is what has been pled, and is what's been pled sufficient, not looking for what hasn't been pled, which is what Marathon was having the court focus on.
Thank you, Counsel.
Thank you.
Any other questions? Thank you.
I'll be brief, Your Honors. I think the radical position here, at least as far as I'm concerned, is what good is a written agreement if it's not going to be enforced? This court has a steady line of reasonable reliance cases for a reason, and these are sophisticated parties in this case. The second point about a supposed lack of ability to close, I think that argument fails for a number of reasons. First and foremost, it's not properly alleged. This court has established in its DGJ management, for example, and that's at 78 AD 3rd 442, that if you're going to plead on information and belief, you have to reveal the factual basis upon which you're making that allegation, and that's not done here. Beyond that, there's no falsity in the statement. I mean, as Your Honor pointed out, this term sheet in this situation, it said an anticipated closing by 45 days. It wasn't a guarantee that this was going to close by year end. So I don't see how they've demonstrated any reasonable reliance under the circumstance. As far as the post-term sheet allegations, as Your Honor, Justice Kennedy pointed out, they were in the exclusivity period. There's plenty of case law that says they were bound. Finally, as far as the details that are missing, I mean, one of the most stark details here is there's no allegation as to who at Marathon, or if it even was a person at Marathon as opposed to a broker or somebody else who made these representations. There's no detail on what they are. Many of them are vague. Ideas about using best efforts. I mean, my client did undertake due diligence in this case. Within a day of signing the term sheet, it served due diligence consistent with the term sheet. It then provided a list of items it needed to close consistent with the term sheet, arranged a site visit, incurred $36,000 in expenses. It ultimately didn't work out, but that's not a claim for fraud or for promissory estoppel. And for all those reasons, we'd ask that this court reverse and remand with instructions to dismiss with prejudice.
Thank you, Counsel. Thank you.
Thank
both.
you.
Finally, People versus McCrae.
Good afternoon, and may it please the court, Rosemary Herbert, Office of the Appellate Defender, on behalf of Jeru McCrae. Because the particularized showing required by the Fourth Amendment was not made in this case, the no-knock warrant issued was invalid, and the evidence seized from Mr. McCrae's family home must be suppressed. The United States Supreme Court made clear in Richards versus Wisconsin that the police may dispense with the knock and announce requirement of the Fourth Amendment only upon a particularized showing that knocking and announcing would endanger the police or civilians or result in the destruction of evidence. No such showing was made here. Instead, the affidavit merely recited that Mr. McCrae will have access to weapons as the basis for requesting the no-knock entry, and that basis appears in paragraph 101 of the affidavit. And the affidavit contained no specific facts or information regarding Mr. McCrae.
So it's not enough to say that it was also ghost guns, so he's assembling, or allegedly assembling guns, so that's the worry. That's not enough?
No, Your Honor. I mean, it's the Supreme Court in Richards was very clear that you cannot have a crime category exception. And here it is simply the nature of the investigation, which again became apparent on the ex parte hearing that was conducted where the detective was asked by the judge, why are you seeking a no-knock warrant? And he said the nature of the offense.
But we have a couple, I mean, there are numerous state cases that provide that where an affidavit states that there might be, that the officers might be confronted with weapons, guns in particular, that's sufficient in the affidavit to justify a no-knock warrant. So People v. Brown, People v. Israel, I mean, cases that are cited in the briefs.
Most of the cases that are cited predate Richards, and I think that's an important distinction. It was more of an open question prior to Richards, and in fact, prior to Wilson, which I think was decided 2 years before Richards, it was not even clear that the knock and announce requirement was actually part of the Fourth Amendment, although it had been, widely required. So I think that is a significant distinction here. And here, you cannot simply say this is a gun investigation. which is essentially what this affidavit does. You look at the final paragraph, it is entirely generic. It could be lifted, cut and pasted in any case involving weapons. There's nothing specific to Mr. McCrae, to the circumstances that the police are likely to encounter. And this is not a trivial matter to break down.
So are you saying that they needed to somehow state in the affidavit that he presented some type of danger?
They needed to have some allegations, and it's not a probable cause standard, it's a reasonable suspicion standard. Something specific to this particular investigation, this particular person.
About his nature?
Yes, absolutely, Your Honor. And that's done in a variety of other contexts, and it was not done here. The language was entirely generic.
So the fact that he had access to weapons, you're saying is insufficient then? If you don't couple that with something about his violent nature and possible propensity to use those firearms?
Or again, and we cite to a federal case in our papers which talks about how somebody had made specific threats against law enforcement, something of that nature. And I would just note that in Richards, the Supreme Court, although Richards itself was a blanket rule that applied in drug cases, Richards went on to address situations, and they talk about cases where it's armed bank robbery, and they say in those investigations, by definition, somebody will have access to weapons, but they say that is not enough. You can't have that simple category, and that's what we have here. And then if I might briefly...
Are ghost guns readily disposable?
I don't think there was any...
Components. I mean, it's hard to imagine flushing one down a toilet.
I think, well, I would note that the only basis on which the no-knock entry was sought was sort of danger. Again, we would say that the showing was inadequate, but there was no allegation of destruction of evidence. And I don't think the facts of this case would lend itself to that, but certainly there were no allegations of that in this case. And then I'd like to briefly turn to the remedy that is being sought here, which is suppression of the evidence seized. The respondent relies on the Supreme Court's decision in Hudson versus Michigan, but that case expressly relied on the good faith exception, which New York courts, the New York Court of Appeals, has expressly rejected as a matter of state constitutional law. And it has looked at both the need for suppression as a remedy so that there are not incentives for this type of abuse to be perpetuated. And the intrusion here is a very significant one. There you had a door broken down in the early hours of the morning. That is a very, I think, terrifying experience for the occupants of this apartment. And suppression of the evidence is sort of the least that can be done to disincentivize the police from that type of entry. And for those reasons, we'd ask that the evidence be suppressed. Thank you.
Thank you, counsel.
Good afternoon, Your Honors. Michael Tarbin for the people. To begin, Your Honors, defendant's claim is barred because he waived his right to appeal, and that waiver was fully knowing and
Counsel, this colloquy in this case was just, I don't want to say what it was. It was just really bad, and I don't think it can be saved by the signed waiver. So I mean, you're welcome to go on, but I wouldn't dwell on it. If you want, state what you want about the waiver.
Sure, I'll be brief then, Your Honors.
But I would not,
Sure,
don't
we do
make
address
your whole
that in
argument about that.
There was a very detailed written waiver, and the defendant assured the plea court he'd read it and he understood it before he signed it. I think that does cure any omissions in the oral colloquy. In any event, Your Honors, as to the merits, there was a particularized showing here, specifically the 60-odd pages in the affidavit that show the defendant had ghost gun parts and ammunition mailed to this particular apartment. And of course, all the showing that he and his partner were assembling ghost guns and selling them. So it was not only ghost gun parts, but ammunition not only sent to the other two apartments that the co-defendant had, but to this one in particular. There's a reason for that. He was assembling them in this. He was assembling ghost gun parts in this apartment. That's the particularized showing that he has ready access to weapons when the police are going to execute the warrant.
Does he have to have made some type of threat to law enforcement or have acted violently in the past in order for, like counsel alluded to, have caused the authorities to fear going in without knocking?
No, Your Honor. There simply has to be under the federal standard, reasonable suspicion to believe that that he's a danger to the officers, and having a loaded weapon would be enough. And in this case, he did actually have an order of protection. He had a prior misdemeanor violation for aggravated harassment, so he did have a history of violence. But simply the fact that the ghost guns were in his apartment, the reasonable cause showing of that was enough to make the particularized showing. In any event, Your Honors, even if that
The apartment lease was in his mother's name, right?
it was, Your Honor.
So should that give us some pause that no-knock warrants can lead to very fraught situations, and here you have someone who was not probably having anything to do with his ghost gun work, who might have been in the apartment and might have had, you can play out the scenario.
Right. And that also weighs on the other side, Your Honor. If they had to stop, announce their presence, give the defendant time to go for a weapon, that would endanger the police officers and the defendant and his mother. So it weighs equally, I would say more so, in favor of the people. In any event, Your Honors, the defendant wouldn't be entitled to suppression even if there hadn't been a particularized showing, because under the federal standard, you're not entitled to suppression. And that because here, in particular, there is no causal connection between the constitutional rule allegedly violated, the no-knock provision, and the recovery of the evidence. The police will recover the evidence in any event. That's why in Hudson, the Supreme Court held that you don't get suppression. The same is true under state law. Defendant didn't preserve his state constitutional claim because he cited the state constitution glancingly in support of a different argument, not in the no-knock argument in his motion paper, so that's unpreserved. But in any event, under People v. Arno, to get suppression under the state constitution, you have to show this causal connection, and he didn't show that here. So he wouldn't be entitled to suppression in any event. Now the defendant argues that People v. Bigelow, that the Court of Appeals rejected Leon, but Leon doesn't matter. The Court of Appeals, the Supreme Court in Hudson not only showed the reason in Leon that you have to show a deterrent effect, it also, that was the second requirement. The first requirement was causal connection, and that's the same as in New York state law under People v. Arno. So you can't get suppression under the New York State Constitution without showing this causal connection. Again, there isn't one. As to defendant's claim that his argument that, well, Richard overruled the piece de largo so far as any statutory claim here, that's not the case. The New York State statutory standard for getting a knock provision is lower, and that was the independent state requirement. It didn't purport to interpret the Fourth Amendment because this is before the Supreme Court constitutionalized the Fourth Amendment requirement, the no-knock rule in the Fourth Amendment in Wilson. So that still stands. If you want to raise a claim and try to get suppression under New York law, under the CPL, you don't have to make a particularized showing. So there was a particularized showing here, and even if there hadn't been, the defendant couldn't get relief. If there are no further questions.
Thank you, counsel.
Very briefly, Your Honors. First of all, with respect to the Arnaud case, which my adversary has cited, Arnaud was decided prior to Bigelow and prior to some of the cases that we cite in our brief, Galena, Taylor, and other cases, where the Court of Appeals has applied suppression as a remedy for either statutes enforcing constitutional provisions or the constitutional provisions themselves. If the Arnaud, as sort of kind of conceptualized by my adversary, if that were the rule, those cases would be wrongly decided. And I think it's also significant that in Galena, again, one of the cases cited in our brief, the court specifically addressed the Arnaud concern and basically said, we don't buy it. That case involved statutes dealing with wiretaps and eavesdropping warrants, and they said because of the violations of those statutes touching upon constitutional protections, that that suppression is warranted here, as in many other cases in violation of the eavesdropping statutes, because of the potential for abuse. And that applies here as well. There's a potential for abuse. And I must say, I don't understand my adversary's argument that somehow under the CPL, the constitutional standards for particularized showing can be either dispensed with or lowered. That is not the way the Constitution works. New York may impose stricter requirements, but they cannot impose lesser requirements. That is simply not permitted by the Supremacy Clause. And for all those reasons, I'm happy to address the appeal waiver if the court would like. We've identified a number of ways in which we believe that waiver is defective and should not be enforced by this court. Thank you.
Thank you very much. Thank you both.